15, we'll start the public hearing. We read the appeal of the Osprey Lake Alliance, William Bartowitz and Tammy McPherson. Lake Alliance, William Bartowitz, Tammy McPherson, by and through literally Bismarck and Spellman PC filed this appeal to the town of Effingham planning board decision to conditionally approve Mead LLC site plan application. When the site plan violates the town's 50-foot setback requirement under Article 4, Section 402 of the town zoning ordinance, stating in support as follows. You know, this is the only thing that's in the appeal is the 50-foot setback. So we're gonna stick tonight to just the 50-foot setback. We're not gonna talk about the gas station. We're not here to vote on the gas station. We're here just for the appeal of the 50-foot setback. Is everybody okay with that?
I'm okay with that, sir. We also raised the 2,000 square foot limitation of the store in our appeal.
It's not in the appeal that I have.
Wow, sir.
Only thing in this appeal is a 50-foot setback requirement. You go into the background, and in the background, where you're giving us a rundown of what has happened in the course of the 3 years here, but that's not in the appeal.
If you look, sir, at their beginning at paragraph.
That's not in the appeal, it's in the background of what they've gone over the course of the 3 years. Oh, I read that.
Starts in paragraph 47, sir. Paragraphs 47 and 48 of our appeal talk about that. 2,000 square foot limitation of the store.
I'm not there as well. But you might.
Yeah, once you get a firearm.
They give you name and.
My name is Byron Bedard. We've got a lot of our grant parents development, and I. That's different. No, sorry. My name is Byron Bedard. I work for the law firm of Ransmeyer Spellman. Represent Tammy McPherson, Bill Bartowitz. I did file a letter back in October asking to have Osprey Lake Alliance removed as an appellant on that matter, and I'd asked the board to grant that. But yes, I agree with you, sir, that we've challenged the 50-foot setback requirement, and we've also challenged the 2,000 square foot requirement with respect to the store moving forward in its current condition. Those are the two things that we've alleged in this appeal.
Well, it's 2,000 square foot. So. Okay.
Thank you. Our appeal is very straightforward and very simple and basic. And by that I mean we allege that if you take a look at the plan here, that this is the August plan filed by me with the planning board here. Yeah, sorry. You have here a proposed diesel pump and canopy. You see a 50-foot setback line right in the middle of it. You also have the underground storage tanks here. They are predominantly within the they're predominantly within the setback right here. You also have you also have the pumps to be installed under the existing canopy, also that's the setback line, and then you have the oil and water separator here, as you see down here, also in the 50-foot setback line. all these items are structured the way your zoning ordinance is defined. And they are, i.e. fixed to the ground. They are all interconnected to each other, and they sit predominantly within the 50-foot setback. That is our basic argument, is that these things here should have been dealt with at the planning board level as to how you cure this issue. They either have to move back, they have to come here for you for relief, or there's something else that's done in order to make them not in violation of the setback for this kind of structure in this kind of zone. The remaining part of the argument is that the existing store here is in excess of 2,000 square feet. And it has been here prior to zoning. However, since the store has been shut down since sometime in early 2021, there is some argument as to what date that is, but it's somewhere between March and May of that year, that the store itself, now to bring it back as a use, would have to be brought down to 2,000 square feet, because your zoning ordinance requires that a retail store in this district be 2,000 square feet or less. And according to the tax records and other information we found, the store appears to be around 2,700 square feet. That is our basic argument, folks. That is what we're here to complain about. This is why we're asking to send it back to the planning board so that they address these items before anything else moves forward with respect to this project. I'm happy to entertain any questions that you have.
Okay, is anybody here from the planning board that wants to weigh in on that?
I am, but it may be better to hear first from the applicant's attorney. Whichever way you want to do it, Mr. Chairman.
Okay, I think we should hear from the planning board first. They're the ones that made the decision.
For the record, Mr. Chairman, Chris Bolt for the planning board, Donnie Chandela over in Meredith. Simply put, as you well know, and as you said earlier, Mr. Chairman, this matter has been before the town boards for over 3 years. Started with this board, and it went to court. It's gone to court twice. This board issued a variance. It had 3 specific conditions of approval. Having a similar plan in front of it. You knew it was going to be a gas station. You knew it was that store. You knew where the pumps were. That kind of thing. We, as the planning board, spent 2 years with this project. It went back and forth to court. It went back and forth to you once in that interim. What we viewed as the court's imprimatur on your decision is we had to apply 3 conditions to the site plan regulations. Site plan is the planning board's purview. Zoning ordinance is your purview. You did not require this pre-existing site to have a variance for the 50-foot setback for those structures. You did require site plan approval, stormwater management plan, and spill prevention plan. And those are the things the planning board dealt with in detail, giving 100-paragraph notice of decision finally in August of last year. Now, that decision has already gone by Attorney Bedard's clients to Superior Court challenging that. They brought it also to you in a dual track, completely legitimate. We understand that. However, they're asking you to change your decision of 3 years ago by adding yet another condition of approval. They're also ignoring the fact on this 2,000 square foot building issue that I think is truly a red herring. The issue of this applicant had the process of shutting down the business to get the new business going in place, and has been stalled through all of these appeals to Superior Court. I'm concerned now. From a municipal lawyer standpoint, great respect to Chris. That we have a change in statute through House Bill 1661 of now a year and a half ago. Actually, it became effective a year ago, Tuesday. That allows applicants like Mr. Johnson's clients to get attorney's fees from the town for bad faith decisions, or from abutters that are bringing what the court might view as a bad faith action. I raise that as a caution. I'm raising it to all of my municipal clients. Be very conscious of what you're doing and the whys, because if you were correct in saying you're only here for this 50-foot issue and arguably the 2,000-foot. You can't be tainted by some of the arguments that may be made of this gas station should never be here. Okay, so my caution is looking at the entirety of this 3-year record. This board was very clear in what specific conditions it wanted the planning board to deal with. The planning board went to huge lengths. I've lost count of the number of meetings that we had. 22, 26. I haven't had a case in 35 years that has had 26 meetings. I'm sorry. But it's one where this planning board did what it was supposed to do. To say that it didn't, I think, is just wrong. And with that, I'll take any questions you have and leave the rest up to Attorney Johnson, representing his client.
I guess like the only thing I think the board might be interested in knowing, Chris, is why, in your opinion, why isn't the 50-foot setback and why isn't the 2,000 square foot an issue? They'd like to.
Sure, 2,000 square foot is the easy. You cannot penalize an applicant for not operating during the window of time they're trying to get the approvals. You know, simply put, they are still grandfathered, in my opinion. With respect to the 50-foot, again, you had structures that are there. You had structures presented to this board in getting the variance for this operation. And it's the state highway which has that huge right of way. It's not a town road or a subdivision road where you're trying to make sure there is a possibility of space enough to expand the road if it's needed. That it won't be done in my lifetime. It may be not done in the collective lifetimes of anybody in the elementary school to widen 25. You have, there has to be a large unexpected influence of people in Western Maine or Eastern New Hampshire who warrant that large highway already for this area to be expanded further that would go outside of that setback already. So you've got things, and the closest thing to the right of way is actually the drainage structure that you really want that close to the right of way. You don't want it in the middle of the property. You want it so that it is on the edge catching everything. And we went to great lengths as the planning with our engineer, with the applicant's engineer, listening to the abutters' concerns, the public's concerns, making sure that that thing was actually in the right place, built the right way, having the right outlet, not on the steep slopes, and got that changed. So it's one where the planning board was very diligent in looking at your conditions of approval and making sure they were properly implemented. So my look at it is, if that had been an issue for the ZBA, that you needed to get a variance for this 50-foot, you come back and ask us for something more. It should have been listed 3 years ago. Now it's, I think, too late. Okay. Did I answer the question, Chris?
Yeah, does anyone have any more questions for Chris?
Thank you for the token.
Mr. Johnson.
Thank you. Matt Johnson, Divine Millman, on behalf of the applicant, not the applicant of the appeal, but the underlying applicant before the planning board, Mina LLC. Thank you. I'll try to touch on a couple points and not reinvent the wheel. Attorney Bolt's already touched on some things. Relative to the convenience store issue, I think it's also important to note that for most of the time, not only were there appeals that stayed any action by my client because opponents of the application filed appeals to the planning board, which then stayed the ability for them to do anything, but the board of selectmen had also issued a cease and desist letter. And so for only until very recently, the whole front of the store is torn up, and it would be a health risk and a safety risk. And so that was the other reason why the store has not been operated. But my client maintained all his permits twice during this process, asked the board of selectmen if they could pave over the area for that, and we're not allowed to do so. But so that's not a knock on the board of selectmen. The reason I bring that up is as further proof that there's never been any intent to abandon the use of the store. It's just been precluded from using it while we're working through the development process. And so he would be ready to go as soon as he's permitted. The planning board process has not been completed yet. The planning board hasn't signed the plans yet. And so that's the stage we're at. So I do think that the ZBA should dismiss the appeal relative to the 2,000-foot convenience store. And we had 26 meetings, and if that subject matter was brought up, it was brought up only, once or twice. It really was not the focus of the issue. And the 50-foot setback issue was not brought up, or if it was brought up in a very minor fashion. The almost all of the meetings before the planning board were addressing how to meet the condition the zoning board had put onto this was that it had to meet the stormwater management guidelines, and that's what we talked about. And the planning board decided they needed an outside engineer, which my client had to pay for. My client has put these items in to protect the stormwater and protect the drinking water because they're in a location that has been signed off on by both my client's engineer and the third-party engineer as being the way that you have to construct this site to best protect the groundwater and best make the most safe site. And so for that reason, your variance required my client to comply with the stormwater management guidelines by DES. To do that, technically, you had to put these items, the underground, the steep sump, the oil water separator, all of the items they complain about in 50-foot setback. Another point on that issue, I believe the board should consider these underground structures as utilities. These are like utilities they put in. I'm not aware of the ZBA requiring setback relief if you're putting something underground. All of these items for the stormwater are below grade. So I would submit under the ordinance, they're not structures and they're not buildings, and a 50-foot setback does not apply. So for that reason as well, it doesn't apply. And relative to the pumps, there's a specific, the planning board looked at the more specific focus portion of the zoning ordinance, section 1005, which regulates automobile stations and has a specific setback requirement for pumps of 25 feet. And the plan meets those setback requirements. And so those setback requirements supersede the general 50-foot setback requirement that they're complaining about, because that setback requirement is specifically for the use of an automobile gas station. And the plans that submitted meet that 25-foot setback requirement. The canopies are there because canopies are part, one, it was already pre-existing over the gas station. The other one is there because the planning board wanted the canopy over the diesel pump, and improves the runoff, protects the customers using gas, and is there for safety reasons as well. But again, that we would submit would fall under that more specific portion of the zoning ordinance section 1005, which has a different smaller setback requirement, and that was the setback requirement that the planning board applied correctly in determining we met those conditions that the zoning board put on us with the variance to go to the planning board to get site plan approval. It's for those reasons I asked the ZBA to dismiss this appeal, allow us to complete the planning board process. I'll take any questions.
Okay, anybody got a question for him?
I'm just curious, I'm new here. Has the structure changed at all since prior to zoning? Is it always?
The structure is there. The structure is there, the convenience store is not changing, the pump locations are not changing, the gas canopy has been there forever. The diesel pump location is the same, but there wasn't a canopy, there will be a canopy there. That's the only addition that I'm aware of, is the canopy. The pavement, the impervious pavement was not being increased. We did shut down the laundromat, so there's a little bit less dense use on the property. There is nothing changing with store configuration whatsoever. And so it really is as it was. And the only slight difference is the underground location of the underground storage tanks is slightly different with the new double walled tanks that DES approved. So those are slightly different underground, but all of the above ground items are staying in the same location.
Okay, the store square footage is over the amount that the ordinance requires. But the convenience store was there prior to the zoning regulation.
So yes, our evidence suggests that the market has been operating since at least 1991, which is 9 years before the zoning ordinance even came into effect in 2000.
So it's pre-existing, so we can't change that use.
Correct. Our position as a pre-existing use predates the zoning ordinance. We're not seeking to expand it. We're not adding an addition to this square footage. Nothing is changing with the interior of it other than the updated point of sale system, and obviously they'll fix up the inside, but there is no exterior change. We're not expanding the use in any way, shape, or form. So our position is the convenience store is a pre-existing non-conforming use.
Okay. You want to counter that?
I'd like to,
Okay,
I'd be disappointed if I didn't. Let me take the comments in order that my esteemed colleagues made. And that is, the planning board seems to be focused on the fact that this board granted, I said this board, the ZBA granted the variance. I understand most of you folks, if any of you were not here back in 2021. But that this board granted variance back in 2021, and that should take care of all of this. And they would take great pains trying to follow the 2 conditions that were put on that variance. It should be noted, and I'm sure the certified record from that variance with you folks, if you'd like to have a copy of it still. That variance is for relief from the Aquifer Protection District, which prohibited having a gas station or a service station in that Aquifer Protection District. It didn't have anything in there about setbacks, didn't have anything in there about the store. And I will acknowledge that back in 2021, I don't think they had an abandoned issue with the store. One of the things, though, that did come out in that variance proceeding is that your council determined that the gas station use of that property had been abandoned. It's an email from Matt Surge to the ZBA back in August of 2021 on that issue. And so from that standpoint, the gas station portion of this was considered abandoned. And so anything that you could do under your zoning ordinance by some other mechanism other than a variance with respect to that gas station required a variance or some other compliance with the zoning ordinance. And so from that standpoint, if they wanted to have the setback waive, they could have asked for a variance then. They could come back after the planning board's done with this and ask for a variance. There's also the reasons to it, but there's no variance for the setbacks on this property. And the gas station use was abandoned. So to the extent that you're trying to say, well, the gas pumps are going in the same spot, the diesel pumps going in the same spot. That's fine if you abandon that use. By abandoning that use, you comply with the zoning ordinance. And so from that standpoint, we believe that the new canopy, and to the extent that the new pumps are inside of 50 feet, that's requires variance. Now, with all due respect to Mina's contention, it's a different setback for gas pumps. I think that's misreading the ordinance. And by that, I mean, section 402 of your zoning ordinance contains different setbacks from different properties for different zones. Some of those setbacks are less than 25 feet. And so I suggest to you that it's not that gas pumps are only supposed to have a 25-foot setback, as Mina suggests, but rather that when the setback is less than 25 feet, that they have to have a minimum of 25 feet. And to the extent that the zoning ordinance for that zone requires a greater setback, then that greater setback would apply, rather than the view that Mina's taken of section 1005. With respect to operation of the store being abandoned, the cease and desist order that was in place, as I've seen, as I understand it, with respect to the gas station, and it occurred as a result of Mina installing underground storage tanks there without having a building permit from the town. And they dug it up, they put them there, they knew that risk. That's come out in the hearings previously. The town shut down for that. They did not shut down the store as a result of that. Rather, Mina by its own work there, that they then going to follow through on, abandon the store by virtue of that. And so I don't think it's as black and white and they make it out to you that, geez, we just couldn't do this. The reason why we just couldn't do this is because we just didn't know what we're supposed to do. We went in ahead and installed underground storage tanks without having all the appropriate permits and tools in place. And they should not be entitled to benefit from that with respect to this facility. And so that's my response to what you've heard from my esteemed colleagues in the planning board and for the applicant. And I'm happy to entertain any questions you have on that. But that is the position you take, that this is not some sort of frivolous out of left field request. It's something that everyone has to deal with when you come in for site plan with respect to these zones, which is you have to meet the setback requirements for obtaining some type of relief.
Basically, we're looking at this, that they got a variance for the gas station, but they still have to look at, we're looking at it as a new gas station. It's not looking at it as the previous gas station.
That's correct, sir.
That's right.
Well, just the fact that the gas tanks that was put in prior to the zoning. Am I right?
When this project started, there were no gas tanks in that property. The gas tanks in that property were removed in 1995, and they discontinued the gasoline use on that property.
2015.
Just right.
8 years.
What?
8 years.
Well, 6 years. 6 years by the time they started the project. But as a practical matter, they abandoned that use because they removed the gas tanks, they removed the pumps. All of those things were gone. The only remaining evidence of the gas station there truly is the fact there was a canopy there. And I've not raised the gas and canopy in our appeal. That structure is there, it's entitled to stay there. But the fact you're going to now install gas pumps there, they're within the 50 feet, that you're going to put another canopy there next to it within the 50 feet, and you're going to put underground storage tanks in there, that's a problem. That's something that they should have addressed either by moving it back or coming to you folks for relief. And that's why we're appealing.
So the variance that they got from the zoning doesn't cover that 50-foot setback.
It does not say anything about it. It does not say anything about that in the various applications they filed. That was not any part of the record in that case, sir. There's nothing in there about the setbacks in either the application that they filed or the variance they received.
So in 3 years, you never brought this 50-foot setback up. Is there a reason for that?
Sir, there's a lot of things going on in this case, but those things were brought up. Okay, there's one by name Corey Lane, who sent a letter in to the planning board before they made their decision. That was an email dated June of this year earlier that raised the setback issue. So a fellow named Tim Otterbach did the same thing. Bob Newton, who was a consultant for my clients, submitted a report, and he raised this issue of the canopy, the plans that were submitted. You couldn't tell what was and wasn't actually being proposed there, such that the diesel canopy did not actually truly appear on the plans until the end of June 2023. So from that standpoint, sir, this issue has existed for a while, but to say that we're just bringing it up now ignores the fact that it's been brought up in the process and ignored. I'll be candid with you, our focus has been the Aquifer Protection District here, that's really at risk here. But geez, just can't overlook the fact that there's a setback here that people have been abiding by, and there's a means of dealing with it.
But Byron, what about the special exception that they received for, under section 702, which kind of gives this generic, I'm just asking for your position on this, kind of gives you this generic language that says the previous non-conforming use can essentially be reignited, as long as you're not expanding to dramatically, I guess, on the original structure.
I don't think there's a previous non-conforming use there. It was abandoned, so I don't think you have any vesting or grandfather in there that would tie into that section. It's protection under the zoning ordinance.
And lastly, so it's your position then that the tanks are a structure, unlike what the applicants are.
But the tanks are definitely structured because they are connected to the pumps. There's at least 2 pumps that are within the 50-foot setback, and candidly, it's really an integrated system. You view the canopy with the tanks and the setbacks, etc. But certainly, you have pumps within the setback limitation. They're directly connected to the tanks. So I think they're all connected in the way your zoning ordinance reads. That makes them in violation. I would say this: their argument is that the water separator is a much more compelling argument because that's not integrated with the tanks and pump.
How far within the 50 feet are we? Just keep saying within the 50 feet. What are we talking 20 feet in, or are we talking a foot and a half?
I would suggest to you, sir, some of them are inches, some of them are feet. And I say that from the standpoint of I'm not an engineer,
Right.
okay, and I'm not the surveyor who prepared this. But if you look at this plan here, so these things here, these are the pumps underneath the gas and canopy.
Right.
One of them really sits inside of the setback, but canopy is about a pump length. The other one's half width there. If you look here at the line, and I have a set of plans I'd have to share with the board so we can have this line here, most of the tanks are inside of the 50-foot setback. Some of them are, just based on a rough estimate here, about 20 to 25 feet. The canopy for the diesel station here, about half it sits in there. So looking at this here, that's probably on the order of about 8 to 10 feet sitting into the zone. And to keep my promise to you folks. Approach. So this is the plan set at that block. Sorry. This is the plan set that block comes from. Okay, that's the site plan shown. The one thing I ask you to keep in mind as you look at this plan set is that, the existing conditions plan that is shown on here is, in our view, inaccurate. Because the existing conditions plan notes this canopy and those pumps as being existing. They are not existing. If you went there right now, tonight or any time in the last 6 months, there's no canopy there that these are supposed to be. There are no pumps in place. It is a raw construction site with dug up dirt. The tanks are in, but the tanks are not fully covered. Yeah, go out there to look at it. I mean, most people probably drive by it. The only things I've driven by a bunch of times, which is why I can tell you what it looks like. That helps.
I have a question.
Yes.
You're not making the same argument over the gas station convenience store with respect to the 56-foot setback. You're making the 2,000 square foot argument,
Yes,
but not the 50 setback, which clearly violates that. Right?
that's correct. The store does not violate any setbacks. It's our knowledge.
Okay. Oh, yeah, I got the wrong line. Never mind.
Believe me, it's not easy to fall into different lines. And I'll say this, I'm not criticizing who misses.
I'm not an engineer either.
Right.
Okay. Anybody have any more questions for Myron? Anybody?
Yes, sir.
Okay. Mr. Bolton would like to speak again.
Thank you, Mr. Chairman. The one thing that this hearing has jogged memory on, and the chairman of the planning board whispered in my ear, is the 25-foot setback was discussed as the appropriate one. And if you look at the actual language of section 1005, it does not say anything about unless another distance applies. It clearly says for automobile service stations that the following site requirements and improvements apply. And it says pumps are to be located no closer than 15 feet to any building or 25 feet to the right of way of any street. That's the one that applies, not this 50-foot one. Okay, and I believe the plans that have just been handed out clearly show that that was the requirement the planning board required, and that was met. In fact, one of the instances, it was determined that the diesel pumps were closer than 15 feet. One of the abutters, or one of the complaining parties, might have been Ms. Corey, brought that to the attention, and the planning board required that pump to be moved so that it complied with this section. This is the right section, not 50 feet. Apply this section and we're done. Thank you.
I won't read Matt Johnson again, just one further point I would note, you can look at it yourself, but the appeal by the applicant does not challenge the location of underground storage tanks. Nowhere in that I read it does it mention it as say that underground storage tanks are inappropriately in a 50-foot setback, and they are in the 50-foot setback. And I would just echo what Attorney Bolt said, the right measurement, the notice of decision from the planning board specifically addressed the setback requirements and said my client's plan met the 25-foot setback requirement under section 1005. The planning board did it right, the appeal should be dismissed.
Okay. All right, public will have a chance to speak.
I'm curious first before I say anything, because I thought we were just gonna talk about the 50-foot setback. The attorney for the town planning board has talked a lot about some other things. And in my 30 years of attending municipal meetings, I don't think I've ever seen an attorney not speak up for the town. And I'm like one of the only taxpayers in this room, and I'm really kind of mad, not at you. You guys are doing a good job. And I wouldn't want to be in your position. But anyway, back to this 50-foot setback. Section 402, pretty basic. There's a little chart. I tried to copy it and I couldn't copy it, but you can look at it online. It's a little chart. And that's what we're here to talk about. So I don't know what they're talking about with this other section, what's allowed. This is a planning board section. This has nothing to do with the previous variance. This is about where things are located. And I have a personal story. I'm so mad. Last summer, the zoning officer called me up and told me that my rental cottage next door was in violation of the 50-foot setback to the front line, because my renter had placed her pop-up tent 10 feet too close to the road. It was in that violation place. And I said to her, like, you're asking me about a tent? And we have illegally installed gas tanks in a drinking water protection zone? Seriously? But I moved that tent that day. And my point is, you can't just make me do something and not everyone follow the same guidelines for that 50-foot setback. And so that's why I hope that you'll really look at this carefully, because this is about all setbacks in our town. That is one of the laws in the zoning ordinance, and you're the zoning board. And the planning board overlooked that when they were looking at this application. And so that's why we're saying, go back and either move your tanks out of that right of way, that zone, or come back to the ZBA and ask for a variance so you can put them there and they're going to be violating the 50-foot setback. It's that simple. Thank you.
Hey, anybody else?
Hello, and thank you for your time. My name is Corey Lane Porter. Few things, as you know, this has been going on a long time, but that section 1005 that Mr. Bolt had mentioned. Sorry, that states number 3, the pumps are to be located no closer than 15 feet of any building or 25 feet to the right of way of the street. This is not a right of way to a street. This is the DOT property with the wetland buffer. They are acting like, well, Mr. Johnson's letter had stated the gas was there, that's there. All these self-inflicted wounds, we know that nothing is grandfathered. It's lost its grandfather status per Attorney Surge. There were, other things brought up that I feel aren't accurate with what has been going on. And again, the letter from Attorney Johnson contained many misstatements in it. And all self-inflicted. They installed these tanks without approval. They did it knowingly. Mr. Doucette even wrote a letter saying, hey, we know it's wrong, I'm paraphrasing, but we're gonna do it anyway. And since then, they've been acting like they've been harmed by having to meet the standards of this law. To say there were 3 conditions on the variance issued, there weren't, there were 2. It was turn the prohibited use that was in place to protect the health and safety of citizens into a permitted use, and then to have a stormwater management plan and the spill prevention plan, the SPCC, which they were required to do, but there was nothing in there saying violate any setbacks you want so you can shove this gas station into the aquifer. None of that was there, yet they're implying that they're being harmed by having to meet the standards. They need to meet these standards. That 25 feet is bogus. They're dumping See, the things that could be eliminated is things like dumping contaminated stormwater into the wetland buffer. That's prohibited, but the planning board refused to address that, and they wouldn't even put it in the 100 findings of fact that that wetland existed. They ignored the steep slopes. You enforce this 50-foot setback, it moves it away from the steep slope that dumps all the contaminated runoff during heavy rain events into this wetland. It eliminates a lot of health and safety risks that we're supposed to not be allowed to protect the people. Now they're saying, we don't want to meet that because we can't. Well, if you can't meet the guidelines of the ordinance, you can't do it. And to keep crying about these self-inflicted wounds, I don't understand why they think that would work. Everybody has to meet these 50-foot setbacks. Even Ms. Foltz had to move a temporary structure out of the 50 foot. And if you allow them to do this, how many thousands of gallons of gas would be allowed abutting a neighbor's property right up on the property line? 100,000? 150,000? I mean, they've got 30,000 within the setback. I wouldn't want 30,000 gallons of gas pushing up on my property line because my neighbor doesn't have to abide by it. I thank you for your time. I know this isn't easy, and I appreciate your attention. Thank you.
Okay. You don't.
Well, go ahead, Damon,
David Steer, Conway Sound, I just want to make sure I understand exactly what's going on. So, in terms of the store, they're saying that it's like 700 feet too big, so they would actually, to comply according to Ospey Lake and the others, they have to take the store and knock down a wall and make it like 700 square feet smaller. Is that no, literally what they're saying?
In the ordinance, we only have 2,000 square foot of store. In the existing store is bigger than that. But the existing store was there prior to the 2000 zoning regulation.
I'm just kind of wondering if they built part of it into like an office or made like a room that wasn't for sales purposes. That would suffice, or they literally have to make the building smaller. You know what I mean? Like if they took 700 feet and used it for an office, which would not be retail space, would that suffice? Or they literally have to knock down like one of the walls and smush it in?
I don't know. I don't see that. The building was there in 90, I don't know, 92, 95, somewhere in the 90s. In the zoning, right? We didn't vote zoning in until 2000. So the building, you can't change the existing building. Even though it's bigger than what the regulations say, because it was there prior to the regulation.
Right.
So they can't change that.
And then on the other one, the 50-foot setback, so we're talking about all the infrastructure that they want to build has to be 50 feet away, including like all the underground stuff.
That's true, except the tanks, the original tank was in the same place as the new tanks have been put in.
I'm kind of wondering, like, in terms of the applicant, or, you know, if I can answer this, like, how, if you were to grant the appeal, like, just how catastrophic would that be to the applicant's plan with how much would that be a deal breaker? Maybe the owner's not here and I couldn't speak to that, but I was just kind of curious how big a deal these two things are.
I could answer that procedurally for you.
Yeah, that would be great.
If they were to fine for Attorney Bedard, then it would most likely be a remand. And then the applicant would have to come back and ask for a variance from the 50-foot setback. And then who knows what happens there.
Okay. Thank you.
Hi, Rich Fay from Otsby. I'm a friend of Bart's, Bill Bartwitz. I just wanted to address the, why the ZBA didn't talk about the 50-foot setback, you know, way back when. This is one of the recent site plans. We get an update every, seems like every few hours, but if you look at it on the first page, it's dated October 2021, and there's no diesel canopy on there. I don't know if you have the same one, but there's no diesel canopy on that one. Then when you go on to the next year, 2022, there's a deal with diesel canopy. So you guys, likely the ZBA back in 2021 didn't even see a diesel canopy. And like Attorney Bedard had mentioned, this was brought up more than once vocally by the public and also in letters. And I heard it, the problem is that, yes, there were 26 planning board meetings. The public was actually only given an open forum once. On 2 other occasions, they were given limited public access. But when you say, why didn't the public bring this up? It's because the planning board never gave the public a chance to speak. And I have a whole spreadsheet. I should have blown it up and brought it here, but I've got a spreadsheet of what the topic was, and I've got in red when the public wasn't allowed to speak, and in blue when it was allowed to speak, and in bright blue when it was actually allowed to speak, but then only for 3 minutes. So you never heard anybody speak for more than 3 minutes. Nobody spoke twice except for the geologist and the lawyers. And so that's been part of the problem. That's why you keep going around in this attorney loop, is because the public just never gets a chance to talk, and we don't get a chance to talk. People like me that know the abutter very, very well, and I know this case extremely well, I'm never given more than, I was given 3 minutes in 3 years to talk. And, you know, I'm so used to not being able to talk that I have a letter for you guys because I know I'm going to be cut off, but I please ask you to read that letter. It's also a transcription of the May 29th ZBA meeting back on 2021, and I was so interested in it, I transcribed it back then, and you'll find that it's a very loosey-goosey approach to the underground storage tanks, and it's very disconcerting to look at how they approached it, and I'd like you to approach it with a much more sincere, sober approach. I just want to introduce you to Bill Bartwitz. Used to come to these meetings a lot. This is Bill and me and his dog Duncan, and Duncan's a little bit of a rascal. Bill was in Vietnam in 1970 for a full year, and he suffers from Agent Orange. He's 100% disabled. He was never given a forum. He was given a forum once in one meeting to talk, and so he doesn't come here anymore. He's extremely frail. He would like to come, but he gets extremely upset about this whole process. But you'll see when I asked him, can I get a picture of you guys to show the zoning board? He actually went and took his Vietnam veteran uniform, and he's got his medals right there. And he's a terrific guy. It's a little bit curt, but once you get to know him, he's a really nice guy. The other thing I'd like to say is the last thing, I promise, is there's been 26 meetings, and you say, well, that means that it's been really drilled down and everything's gone over with a fine-tooth comb. Actually, quite the opposite. There were often meetings that were stopped because the butters weren't notified. It was stopped because they decided on a DRI and then they had to delay and do a DRI and they had to do another DRI. There's been 7 revisions in the last 2.5 years. The last revision, I think, came in yesterday or the day before. So a lot of the times the revisions didn't come in at the date of the meeting. And I think, Lawrence, you may have been to a couple of those where 50 people showed up and the applicant actually wasn't ready to present. So it had to be postponed and they talked about other stuff. So this has gone on for a long time. And there was also, you know, I'll admit, there was about 5 months where this was in court because The planning board on its own decided that the special use permit would not be a condition for the applicant. And they did this on its own. The applicant didn't actually even ask for that. The planning board decided on their own not to have require a special use permit. And so obviously this goes to court because a special use permit is required when you have 100 gallons or more in a tank, and they have 30,000 gallons or more for a tank. So you could say, okay, well, that was a delay, but who was it a delay on? Was it a delay on the opponents, or was it a delay on the applicant, or was it a delay on the planning board? I'll let you decide, but this went on for a long, long time, and it's not because it was closely looked at. It was because of, you know, you'd have to follow the whole storyline to understand it, but it went on for a very long time. It's still so bad for Bill Bartowitz. If you think of your own land and putting a gas tank 310 feet from your own private well that has no protection, if you're okay with that, then go ahead and vote in favor of this application. If you're not okay with that, require the 50-foot setback at a minimum, and require that the special exception permit be restarted after 2 years, and make sure that the convenience store is an easy thing. I don't even know why they're fighting back on it. Just go and ask for a waiver, ask for an upgrade on the convenience store and go with it. But I hope you guys will really consider this closely. Please read my letter before you vote. Thank you.
Okay. In 21, nobody on this board, there was nobody on this board in 21, so we can't answer the question back in 21. And your statement about the 50-foot, change it to the 50-foot setback, well, that won't change the distance from that well if we change the 50-foot setback. So I understand your frustrations. You should be sitting on this side of the board if you don't see it heavy. So is there anybody else that wants to, okay, state your name and address so that.
Yeah, no, I will, one state. My name is Jeff Wright. I'm from Parsonsfield, and we all know how things flow downriver. We're supposed to talk about the 50-foot setback. Well, I guess if you don't meet the 50-foot setback, you don't meet the 50-foot setback. And you're talking about square footage and grandfather, I like to call it grandmother, but if the store was closed in 2021, they'd have to go back. They have to conform, right?
Not in my opinion. If the gas station and the store was put in prior to zoning,
Sure.
it wouldn't come under the zoning regulation.
Right.
So, no, you wouldn't have to go back.
So if it was like a used building that burnt down in 1928, that doesn't, and could you rebuild it? Could you build it because it was there at one time? This store was there at one time, but things have, the store closed. The store closed, it's over. It doesn't meet the regulations anymore, right? After 2 years?
It's true.
Okay.
Except, he tried to get the store open, but there's been in litigation for the last 3 years. I know it's only 2 year period, but you can't hold them to the 2 years if it's in litigation.
Why was the store in litigation?
Because you keep taking this back to court.
But why was the store? Why did the store get shut down? Did the store get shut down or did they close it?
No, the store got shut down because they sold it. They closed the store up when they sold the product.
Well, it's not like he was open and the town made him close it. He closed it. No.
Yes, they put a cease and desist on it.
Right. I'm sorry. Can you say point of order when somebody's out of order? Right. Well, that's all I get to say is that I think it probably passed its due point, and you know. Thank you very much.
Billy Lund,
Effingham / Ospey. I live right next to the gas station. I was under the impression that the store was only closed because they dug up the tar to put in their new tanks. They could have easily reopened the store. It operated for 5 years without it being a gas station. There was no reason, nobody told them they couldn't open it as a store. They chose to put the tanks in and have this open environment that you can't drive on. So they limited themselves from the ability to have their store open. They abandoned it themselves. They put themselves in their situation, causing the store to be abandoned. I just wanted to clarify that. We didn't do anything to them with the stay or anything. It's all this other stuff that they created for themselves that created the problem of them being able to have a store open. Okay?
Okay. I'm going to try to answer your question in your statement. I believe they tried to get the town to let them backfill the tank so they could open the store. In the town, if I'm correct, the town said they couldn't do it within litigation. So the town wouldn't let them backfill the tanks and get the store open.
That they created because they decided to do that all without prudence, but had they just purchased the store like anybody and opened the store and went to the proper channels, they could have had the store open while they did their gas permits, correct?
This is true. But
A little person that doesn't have deep pockets who errs on the side of caution probably would have had their store open while they went through the permit process.
you're good, you're good,
Okay.
you're good. But I can't argue that. Anybody else have it?
I just want to point out clarification on the store. The select board and each it is public record, included with Rebecca and the select board, they were told, yes, you can open the store, but no, you cannot pay. They were told you can open the store, they chose not to do it because they had dug up the whole parking lot and put those tanks in. It was their choice not to reopen the store. And that is in the public record between the selectmen and Rebecca, the zoning officer.
I have, to that point, Lawrence, I do have the email exchange between Rebecca and Teresa Swanik, regarding that specific discussion, and probably a select board member. I was trying to find it on my phone. It's kind of short notice, but I could, if you can make sure that it's for the record, I can send it to you tonight. I can just go back and send it. I was looking at it today. So the point of the matter is that the select board said that they could reopen the store, and the only reason that they were concerned about the paving was the safety, and they asked them to barricade it, and if they wanted to open up the store on the other side, they were allowed to. And that was the nature of the actual email exchange back in the day. So the opening of the convenience store was an open discussion, and the select board said, go ahead and do it, and the other boards did it. So I'll send that to you.
Do you know what year that was?
I think it was 2021, because I think it was in the fall of 2021. They were trying to get it. I think it might have been ready for winter or something like that, but I'm almost positive of this. I can tell you in the next 10 minutes, probably.
I really think that they tried to get this.
Was that about board of selectmen?
Mr. Johnson?
We did try to pave it. I think you gotta remember a couple of points too. Some of this is entirely a red herring. Because the issue is whether we intended to abandon the use of the convenience store. And our point is we never intended to abandon the use. We wanted to open it safely. And just so you know, again, it's not part of your appeal, but they keep talking about it. We didn't go willy-nilly trying to put tanks into the ground without permits. We talked to the town. This board and gave us the wrong information about what we needed, and we started down that path. And then we got a cease and desist order, and she told us we didn't need anything else. We went forward on that. Then they said we needed to get a variance, we got a variance. We tried to do the right thing, but we got the wrong information at the start of the project, and that's what brought us here. We've never tried to abandon the store, we've always wanted to open it. They've kept us in litigation, they've extended the plan, they're trying to, only they have sued. Not us, so the only people bringing it to the court are the people that don't want this project, and every time, everything gets delayed.
Good evening, everyone. Christopher Siemens, Effingham Board of Selectmen, and I am the liaison to the planning board as well. I just wanted to clarify something. This is coming from me, not the board. I'm not speaking for the Board of Selectmen at this time, but I keep hearing about Matthew Surge, the town council, and there was a dialogue via communication through head nodding between Mr. Taylor and myself about his position on the abandonment. During the time, and I'm sure all of these folks out here who have done their diligence and research can testify to this to some extent, that he at one point in time had made the opinion that it was abandoned. And that was where Mrs. Boyden justified getting the cease and desist order. After our lengthy planning board process last summer and into the fall and last spring, 26 meetings, now 27, but we can't count that one because we're doing a redo tomorrow. When it came time to remove the cease and desist order so that the applicant could move forward with the conditions precedent, I believe I'm saying that correctly, Mr. Surge changed his mind. Do you have that record that he did not say it was abandoned? Does anybody have that record? Because we keep hearing you say it, but that he said that it was abandoned, but he ultimately put it in writing to the Board of Selectmen and to the planning board. His ruling, when he directed Mrs. Boyden or directed the Board of Selectmen as his or her boss to remove the cease and desist order, because it was not abandoned. We don't have that in writing.
Show us.
You guys have done all that work, you come and pound us all the time, but you haven't found that? Okay.
George.
Yeah, I wasn't pretty.
George isn't a selectman. So.
Yeah, I wasn't pretty. Okay, not to have an argument with the selectmen, but Chris, I was.
You just recognize, because you've already got out of order once, and I'm not gonna sit here as a resident and let you do it again. You do not recognize you. You've already overstepped tonight, and you know that, and I called you out on it. If you allow this, it's wrong. It needs to stop.
Okay, we started, I said, were we talking about the 50-foot setback? So are you got something to say on the 50-foot setback?
Rich Bay from Ospey, can I just be recognized? I'll tell you, I'm addressing exactly what Chris is talking about regarding the cease and desist.
Okay,
Can I talk about it?
is this going to tie in with the 50-foot setback?
Well, I'm just addressing what he just said.
No.
Okay, I don't have to say it. I was at the same meeting that he was at first regarding the cease and desist.
So you're contradicting what he said?
No, I'm just clarifying what I saw. What I heard.
All right, I'll allow it, but make it sharp.
Okay, my frustration with the cease and desist went on in, I think it was May 13th of 2021. And the cease and desist was lifted a couple of months ago. And I was at the Board of Selectmen meeting and I was hoping that there would be some clarification on why the cease and desist was lifted. And they were, I'm almost positive I was told that it's under, the attorney told us not to talk about it, but we didn't get any, I was asking for some sort of backup on that, some sort of evidence, and I could see nothing. So It's really hard to say, why don't we have that information? We weren't given, this day, it's a real mystery why the cease and desist was stopped.
Yeah. Okay, anybody else?
Just one more thing, this has to do with the 50-foot setback. I guess I'm totally ignorant on a lot of this stuff, because the planning board, doesn't, broadcast their planning board meetings, that I can watch those meetings, and I'm probably more educated on the 50-foot setback. Transparency is kind of important these days, and that has to do with the 50-foot setback. I could watch, the meetings at home, I could educate myself, and I'd be more educated on the sort of 50-foot setback. That's all I gotta say. Thank you very much for listening.
George. You got anything that you want to add to this?
No, I think that's.
All right. Nobody else? Blair?
My phone's Promising Road. That exchange that we were talking, that they were trying to figure out with Teresa and Matt's marriage was from May 14th, 2021. And the end of it, she says, they should properly barricade anyway, I would think, not just safety flagging. They brought this on and assumed all risk from earlier email letters from that same realtor to me. And the realtor is here, Mr. Doucette, so.
Okay, May 14, 2001. It wasn't abandoned. Well, it was still under the grandfather clause because in 2001, it had been 2 years. So, still relevant as far as I can say.
Point of order, the public comments done, Mr. Chair, and deliberation through it.
But they're saying. And I guess they have, so we will go into deliberation and we will be voting tonight. So the public is shut up. So, I guess we'll start with, has everybody read or literature that come forth from lawyers? Well, yes, Mr. Peggy attended something, I don't know what it means, but that's it. Okay. Has everybody had a chance to read it? Did you give it to everybody?
Yeah, everybody.
All right, let's take a minute and skim through it. We understand what he's trying to say here. We don't want to read this whole thing.
No.
Hey, if you want, the full chair up here and discuss that again.
This seems like a fine distance.
Huh?
No,
We did. We did. We need to just, what happened prior to meeting. It gives us an idea of what the plan. What we give. Okay. Wait. Then you read everything through, right? Everything is said. So. Nobody has a question? Are we ready to vote? Talk about it. Talk about it.
Whatever decision you got to make, findings of facts.
Well, I'm just asking. Anything you want to do? Anything you want to question?
Vision or something like that, I know how they feel.
I just looked that up, you'll find it. I have that. Planning board is. Zoning regulations, they don't know anything. Annexations, so they use. So they. That's what it tell. The other ones. No, no, but that's as close to zoning regulation. That's what they use.
These folks do need to hear this.
Yeah. Yes. Under the protection of
Yeah, well, yes, the zoning regulations. Yes. Groundwater protection. Well, that's what the real was, the appeal. Yeah. No, but.
Without permission or anything, they put them in radio. Well, without. If I like, if I will. I never have a problem if I don't follow it.
That's something, you can think about that. But there's nothing to do. Right. So you change the use, and then you gotta go, you own it. These people bought it without gas.
That's right.
Totally, no, they got a variance for the gas station, you gotta have a variance for that. Actually, yes.
Remember they got special.
They got. They get these special stickers.
Well,
But we were, we're not here to talk about that. I know. I think it's now. And here we are, everybody just throwing it our way, everybody else has to go file it. I don't understand. It's right, we're supposed to be moving down. We follow the ordinance.
The ordinance of the mechanism.
Byron, aren't they supposed to be speaking into mic so we can hear?
The public is.
Well, when fine, but.
Well, so
We don't
the-
even
so
hear-
the print can hear.
Let's move the microphone, so people can hear it, put one here, just go over there, we're all sitting super close, so.
Very much.
They do. Oh, you want that?
Yes.
Oh, right. I know you have it. I'm thinking into that money. I'm sure that there's. Fractions there.
This is section 702, change or expansion of non-conforming use. And this was amended in 2020. Upon approval of a special exception by the zoning board of adjustment, a non-conforming use may be changed or expanded upon a finding by the ZBA that such a change will bring the use into closer conformance with the provisions of this ordinance, or will make the non-conforming aspect no worse. The ZBA may approve with conditions or disapprove requests under this section. Then it goes to B. A use will be deemed to have been brought into closer conformance with the provisions of this ordinance, or have been made no worse if A, the dimensions of the lot or structure are unchanged, or more nearly meet the frontage, setback, or lot size standards of this ordinance. If, and then B, if the proposed use is less or no more intense than the previous non-conforming use as measured by 1, volume and type of traffic expected to be generated, size of the building or structure housing the use, number of potential customers, and number of potential bedrooms.
Well, they got it.
They have it, we're not arguing that.
They got that.
I think the question becomes, does 702 slack on that 50% act?
Well,
It's a pretty existing.
you know.
Now, the pushback to that is whether or not it was abandoned. If it was abandoned, was it?
The gas station was abandoned. Oh, it was abandoned. Oh.
Well, that's a difference.
That's a major difference.
That's,
Like-
yes, that is it.
You know, this is totally new. Totally new gas station. It may be a back, it's a gas station.
We're past it like that.
Right.
The argument
Is
is
50 feet.
by the opposition is that, that this sentiment abandoned. Since 2021. If you find that it has not been. Special exception. It's not. That's, I think, really where the rubber meets the road. Abandoned.
Well, they've also got, like, they also got the all the comments here that they have it. They
Stole.
for the store. Yeah,
That's all that.
okay.
Stole, right? Yeah, they still open after they did the tank cut. Sure, it was stole. But the state made it the tank cut.
Right.
They only have maybe 20 years.
But they got, the new owners got the special exception to put them in. Correct.
No.
Yeah,
Yeah.
they got this, that's my understanding, is when we got the 2021 special exception. That reignites the gas.
Right.
They've got it, they've got the use.
Right.
It's a pre-existing non-conforming use under 72. So, unless it was abandoned. I think that's what you gotta figure out.
The fact that they got the permits. that.
It's sensitive what they would.
Right, like a house is, if you continue to pay the taxes on a house, you don't go to that house for the next 25 years. Legally, is that house abandoned? No, it's paying the tax. Like. I understand there's a lot of emotions going on in all of this, and everything that's happening. But at the end of the day, we need to put the forward actually here. Which is the over. We can talk about this till midnight, back and forth, but at the end of the day. If they're still paying on the property, go ahead. They're paying on the store. The store is the property, that's done. I get it, I get it. I understand. But at the end of the day, it's a very black and white.
We're not here for our own.
Like, no, I get it, I get it. Whoa, we've been getting a ton of emotions from a lot of people. I get it. None of us were here in the beginning of this. And we're trying to figure it out now. So I think we are getting clouded by some of all of those emotions that are coming in. But at the end of the day, was it abandoned or was it not? Right. So. I mean, at the end of the day, I don't have a vote on this. So.
Nice, huh?
Yeah. And you don't either. Okay.
So. I was in sometime in the nineties. Zoning didn't come in until 2000. So the tanks are non-conforming because they was put in prior to the zoning.
They were, you removed in 2015, but
They were removed in 2015.
once again, you got a special exception of 2021.
Right.
So it's on paper, they're legit. On paper, it's all above board. We're not here to talk about whether or not it's was it abandoned or was it not. It sucks, but that's it. But that's what we're talking about. The 702 is if it was not abandoned, the 50-foot setback is.
As per the special exception. If it was not abandoned.
You want more time? No. Big one. Okay.
I'm just trying to keep it good.
Are we ready to vote? I mean, there's something that you want to discuss before we do.
We can take, we're basically, we take a vote and then discuss findings.
Will there be finding of fact?
They will have to. But they can take a vote and then we can talk about findings to support it, but it has to be discussed on where.
They vote before you discuss the finding of fact?
Go either way, as long as it's all there. I was going to talk about, well, what I would do, what I would suggest is maybe you all come to a consensus of where you're all leaning. And then we can discuss facts before you take it up.
Let's do it, because we had this until 9 o'clock. And then 8:57 right now.
Another option is, of course, to continue this.
We're completely on 3 years, they've been fishing in the pond, the same pond for 3 years and haven't caught anything yet, it's time to pack up and move on. Because we read 3 years. Yeah, we can continue this for 10 years, if you get any further. So, I think we should vote.
So what's the vote? How you gonna vote?
Okay, we're voting not on the 50% setback, we're voting on whether the planning board made the right decision or you think they made a mistake in the decision.
Or put another way, Mr. Chair, if I may, I'd rather voting to deny the appeal or grant the appeal. So if you were, put it to you this way, if you were to grant the appeal, you say we're putting forward wrong. Deny the appeal, you say we're putting forward.
Okay, everybody happy with that?
Quick question, I didn't hear your private discussion, but are you splitting this into the store issue and the 50-foot setback issue?
Comment.
All together.
Yeah. Public comment.
Doesn't work that way.
But it's all under, but since it's set, it's all under one roof. All right, the 50-foot setback or the 2,000 square foot building is all under the same roof. So if you were to grant the appeal, say the planning board was wrong, and those two issues would have to be addressed later somehow. If you were to deny the appeal, you'd be saying that section 702 of the zoning ordinance prevails, it's a pre-existing non-conforming use, and therefore the 2,000 square foot issue is saying it doesn't apply to pre-existing non-conforming.
Everybody understand how you vote? You ask me.
I mean, let's word the motion. The motion should be moved to either grant or deny, who's ever make the motion. The appeal. Take your vote, and then we can discuss the supporting facts to support the vote.
We go, where would we go back?
Because you're gonna have to justify your decision.
Well, I think you justified that with all the look to it, we read.
Get it on the record. I need it on the record. We'll work on it, don't worry, it won't take long.
I'm gonna grant it.
So make the motion. Make the motion.
Could each member speak into a mic at this point?
Make a motion, we grant it. A second.
Okay. Motion been made and second. All in favor? Aye. Okay. Now, we vote on the appeal.
What did you just vote?
You just voted on
We
it.
didn't vote.
Did you just take a vote? You just.
I did.
What was the count?
To appeal. Was. One, two, right. Did you vote?
Yes.
4, 5.
So who voted in favor? The motion. Two. So it's 2 yeas and 3 nays. Yeah, so the motion, so the vote fails. 3. Then other motion. Right?
I don't think they understood which. which way they vote. Put it in.
You made, you made a motion to grant the appeal. Second, the two of you said aye. Three of you say nay, so it fails. So let's do another motion then. Deny, right? Making that motion.
You have a show of hands. Please.
It's just two of us that said we granted it.
So raise your hands. And those that voted nay, raise your hands. Okay. So that fails. We'll take another one. I would advise you to make a motion to deny the appeal.
Make a motion to deny.
Second. Okay, been a motion and seconded. All in favor of that?
Raise your hands. Okay, three.
Yeah.
Opposed? Two. All right.
All right, get that down.
So then I read that as an affirmed motion to deny the appeal. So now, those that voted in favor to deny the appeal, why did you do so?
Guess I'm gonna keep it. All of the,
Microphone.
all of the literature that I read, in the fact that they got any approval from the ZBA. And they got us approval for their special exception. In the fact that it's the property shouldn't be underneath the zoning regulation because it was prior to the zoning regulation.
Seven oh two already be voted in. It would be basically, we're just voting on it. It's already covered, 702. So all the special exemptions are already classified, and you really can't go into higher in the direction. So it comes down just in the word of 702.
Right.
We fall into that category, so what we can do, we can't do anything else about it.
Exactly, and I agree with section 7, change or non-conforming use. Or the meter, you can't change.
You're paying one over here, let's do.
Right.
Do the naysayers want to say why they're going to do? All right, that's all.
Not right.
I'm sorry, but it's important to hear what you're saying.
Well, I'm just saying, some of the things that I've read that are sounding contradictory to me, that's why I voted the way I did.
I will, I'll draft it with notice of the decision. Okay. How? 5 days, get a notice of decision now.
5 days is gonna.
Fine, off.
Well, we gotta get up here, we have it tonight.
Well, adjourn.
January 3rd.
Second.
Aye. Yes.
It's the wrong way, right? Thank you very much.
Oh. You're going to see a bookkeeper tomorrow? Yes. Thank you. Yes, right, it'll make your life a little easier. Thank you. Appreciate it. You're welcome.
All right,
I call it. It doesn't make sense. That's it. I need to think about
So are you talking about the gas?
Not to say, all we're doing.
Yeah.
Pretty much. We're not here.
It's over for us.
All right, he'll come back. So then.
No, we all. This is. So all this is all.
They sign off on it. It's a normal world.
But then, but. And you have the right.